So today, as you can see, we are going to discuss one of the very most important concepts and the previous year asked questions also regarding the amendments in specific relief act for the year 2018. Are the amendments which have been taken place? So before you start this question to read, practice this more for the mains examination also. So let us go immediately into the content. So the Amendment Act 2018 has a lot of changes and there are most significant changes which has happened. So before starting your answer, you need to write it has received the President assent on 1st August 2018 and it has come into force on 1st October 2018. So the key changes in the sections involve these set of sections. Section 6, 10, 11, 14, 14A, 16, 20A, B, C also and 21, 25, 41 of subclause HA and in the schedule. So before going into this video, let us understand three terms better for understanding this amendment in 2018. So in this explanation, I have used three terms. First thing is amended, the other one is substituted, and the final one is inserted. So before understanding this question, let us understand what are these three terms specifically and when are these terms used. So amended is something that there is a provision. So let us take there is a section, there is an explanation, for example, and in that only a part of that section has been changed or modified. Then we need to term that as an amended. This provision has been amended. So you will term it like that. While coming to substituted, there is already an provision or a section related to some, for example, there is already a section and in that section you are completely removing the section and you are adding a complete new part. Then you will use the term as substituted. Whereas inserted is something that addition, you need to remember this as adding the provision or adding the particular section or the statement or content where before, prior to the amendment act, there is no such section. Only after the amendment only that section entirely is being inserted. So don't get confused. For example, there is section 14 here and there is section 14A here. So before amendment, there is already section 14, but 14A has been inserted. So here you will use the term inserted because there is no 14A before 2018 amendment. So understand these three terms: amended, substituted and inserted. So now let us go into the explanation. So starting with section 6. So section 6 is amended. That means there is already the same provision but few terms have been added. What are those? So suit by person dispossessed of immovable property. So in this section, after the words he or any person, so this is actually there in the old law. The words through whom he has been in possession or any person are being added. So this is an amendment for section 6. So these terms are added as per the new law 2018. Now coming to next section, section 10. So we term this as substituted because the entire section has been replaced by a new concept or the new statement. So before under section 10, the enforcement of specific performance is always mandatory, but it has been substituted. The entire section has been substituted stating that from now on after 2018 amendment, there will be discretionary power of the court rather than mandatory. So section 11. While referring to section 11, the nature is it has been amended because only few or the part of terms have been amended. The remaining everything is same. The word contract may in discretion of the court is substituted by the contract shall. So before there is may, and now you are amending it under the term shall. So this gives more discretionary power. So regarding section 14, contracts not specifically enforceable. So this section is already prior in the act, but later it has been substituted under 2018. It has added few more things for the same section, which has 4 subsections which deals with the contracts not specifically enforced are being given in detail. What are those contracts which cannot be specifically enforced? Like substituted performance, contracts involving continuous duty, contract depending on personal qualifications of a party, and contracts of determinable nature that cannot be specifically enforced. So these categories have been established in 2018. So 14A is a complete new section to this act after 2018. So that's why we will be terming this as inserted section. So 14A is nothing but the power of court to engage the experts. So this is a complete new section. So 14A is also added after 2018 amendment. Now coming to section 15. Section 15 is amended. That means there is already section 15 prior to the act, and in this under subclause FA, the things have been added are generally it speaks about the list of persons that are being present. That means who may or like who may obtain the specific performance. So who may obtain the specific performance? The list of persons are given under 15. So for this 15, the clause FA has been added under section 15, which speaks about LLP amalgamations. So this has been added to the existing section. So this has been amended. And there is insertion of clause CA in section 19 as well. It also speaks about LLP only. So section 16 deals with one of the new amendment in the year 2018 which has come. So regarding persons bar to relief. So there are certain list of subsections, I mean the clauses which have been given. So under these clauses, the terms have been modified. That means they have been amended. So section 16 under clause A. So here before it would be a compensation for its breach. This particular term has been amended by a term has obtained through substituted performance under section 20. Whereas under section 16 clause C only, it also states that in place of avertment in the pleadings, right now only the term prove has been amended. So before it is ever and prove, but now it is only to prove. The parties need to prove that they are willing to perform the contract. So as I mentioned earlier, under section 19, it has been amended. The clause CA has been added here into the existing section. So which talks about LLP amalgamations, which have been inserted under clause CA. For 20, it has been substituted. So the amendment has removed the court's discretion to grant or refuse specific performance, and it has added substituted performance in place of it. So this is regarding substituted performance under section 20. So 20A, 20B and 20C, all these three sections are new, only existing after 2018 amendment. So these have been inserted. So these three sections speak about, 20A speaks about infrastructure projects and the special codes regarding it and what is the resolution timeline mentioned under 20C. So all these three sections have been inserted newly. Whereas section 21 speaks about the amendment before this section have been in form, that means it is still existing before this 2018 Act, and now in this after 2018, the term only addition has been there and substitution has been removed. So this is the amendment which has taken place in section 21 under power to award compensation. In this section, the words either in addition to or in substitution of has been substituted by in addition to. So there is no substitution of term after the 2018 Act. So under section 25, it refers to Arbitration and Conciliation Act 1996 now after 2018 amendment, but before it is referring to Arbitration Act under 1940. So this has been amended. So this is the last amendments under 2018 Act. So these both are being inserted. That means they are newly added after 2018. 41 of clause HA and in the schedule. So regarding 41 HA, no injunction will be passed against any infrastructure project. And regarding schedule, the infrastructure sectors have been listed and explained under 20A, B and 41 HA. So these two are newly added for the 2018 amendment. So I hope you have understood clearly regarding the sections, clause and the schedules which have been amended, inserted and also substituted, and the terminology which have been used after 2018 Act. Let us continue with the next video. Thank you.